SJC-13173, Charles Kingara, v. Secure Home Health, Incorporated, and others.
Okay, Attorney Moslinger.
Good morning, Your Honors. Raven Moslinger on behalf of Appellant Charles Kingara. May it please the Court. In class litigation, the most important interest that requires protection is that of the absent class. While there is a named plaintiff in a class case, this Court has described the absent class as the real party in interest. Absent classes often consist of hundreds or thousands of people whose rights are being adjudicated, often without their direct input and knowledge. So it is paramount that those individuals' rights, consistent with due process, are protected. This Court has identified three actors tasked with protecting class members' interests: the named plaintiff, counsel, and the trial court judge. As for counsel's obligation, this Court has identified a continuing obligation to each class member, whereas the majority of courts to have addressed the issue have held that counsel owes a fiduciary duty to class members and that that duty arises at the inception of the litigation. Now, if there's a fiduciary duty owed to absent class members, there has to be concomitant authority to act pursuant to that duty. No court has spelled out specifically what actions counsel can or should or must perform.
Counsel, can yes, but we got to look at where we are in this case. So we have, you're representing one person, you're bringing it as a putative class, but you haven't identified any other potential class members. You know, it's right now it's sort of a figment of your imagination in certain ways. You've not identified anyone. You've had opportunities, I take it, for some discovery. You've not come up with anybody. So it's very premature to conclude that this is even going to be a class. I mean, it's brought as a putative class, but you're representing one party. Your party dies. You don't even have the personal representative authority to continue. So, you know, to give you sort of, you know, this is different from cases where plaintiffs have been identified, or, you know, it's clear that other people know about it. As far as we know, this is just your case, right? Your deceased client's case.
Well, Your Honor, what I would note is that the reason, discovery hadn't really taken place is because we were actually engaged in class-wide settlement negotiations to resolve the case. And then second, this Court has not made that distinction before when attempting to protect the rights of putative class members. And I would direct the Court to its decision in Chambers versus RDI Logistics Incorporated. That's 476 Mass 95, 2016. I was going to address that later in my argument, but I'll address it now. That was a putative wage and hour class action. And during the pendency of the class action and before certification, the employer sent employees who fell within the class definition letters with $1,000 checks and releases of claims. The plaintiff moved.
But there you've got people who know about the case. That's who we're worried about when there are people counting on you. That's a whole different ballgame than, you know, you haven't identified anybody else who even knows about this case.
Well,
right.
I think that would be, in most cases, an impossible feat before taking discovery to have knowledge that other people know about a putative class action. And I don't believe that this Court has ever held that employees' rights can't be prejudiced simply because the employees aren't aware of a pending lawsuit.
Well, no, we focus on, I mean, one, there's not a lot of case law out there, but we focus on prejudice. We give you some ability to push this idea if we think there's prejudice out there. But we don't want you using the court as a solicitation device. That's clear, meaning you're using the court to sort of drum up business. And that seems to be what you're doing here, isn't it?
Well, Your Honor, it is not. Your Honor, we have a fiduciary duty to absent class members as soon as the case is filed as a class action. The only way, if this case gets dismissed, then the tolling that those putative class members enjoyed ends. And
everybody can bring, when your case ends, every single person can bring an individual action, or somebody else can bring a class action. The only case who's over with is your deceased client your personal representative can hire someone else to proceed.
Well,
There's nobody prejudiced by, the fact that you can't get the personal representative to hire you.
well, Your Honor, I don't think that a personal representative is an adequate solution to protect the rights of absent class members. A personal.
You don't have any. You haven't certified a class here. You haven't identified another person who's harmed by this. As far as we know, you're the only one, right?
Well, Your Honor, the courts don't. Many of the courts that have issued notice before class certification have issued notice when there's potential prejudice. They haven't necessarily found actual prejudice.
Yeah, give me a case in which there's nobody else out there identified. I've read some of the cases cited. There's usually people, who become aware of this, where it's a cause célèbre. Give me an example of a case where it's so premature, it's so early in the process, and no one else has been identified where notice is given out.
Well, Your Honor, the Seventh Circuit in Culver versus City of Milwaukee issued notice on grounds that if the potential prejudice was more than nil.
Yeah, but that's a case, and I read Judge Posner's decision in that case. He says this is a case in which the police force is involved. They're clearly people aware of this. It's a big deal. So it's not a case like this one, which is an individual person. That was a case where it was pretty clear that other people were aware of it. I mean, it was a police officer case, right?
Yes, Your Honor. But what I would point to cases in our brief. There's one case, and the name is escaping me right now, where the named plaintiffs ended up settling their case before class certification, and the court, and this is in a footnote, the court issued notice. It looked at all the circumstances and said, I don't think that anyone did anything wrong here by resolving the case, but we're still going to issue notice to the putative class, again, due to potential prejudice that may flow. Your Honor, ultimately, this isn't really an issue of soliciting new clients. It's of giving people the notice when they are potentially going to be prejudiced by dismissal of a lawsuit. I think between sending out notice and not sending out notice, the better result is that the court issue notice to the putative class. Again, it's consistent with due process and ensures that any potential prejudice from someone who may have found out about the lawsuit or someone who simply doesn't know about their rights can remedy that prejudice. I mean, many courts, Your Honor, find that superior.
Can I ask you to identify the prejudice? You're saying it's the lack of tolling. Anything else?
Yes, Your Honor. And also, just if you look at the lawsuit as it exists right now, there is no representation for the putative class. And so they're not only missing, not only is the present representation inadequate, but they have no representation at all. There's no one to vigorously prosecute the claims on behalf of the putative class. So I think on those grounds alone, that is prejudice.
You brought up Justice Wellman, are you done? Sorry.
Yeah.
So you brought up the example of the Culver case. There, the Seventh Circuit was concerned that the lawyer wasn't necessarily a good representative of the class because, again, sort of a lack of success in discovery, lack of success in identifying other clients, a lot of motions that went nowhere. Why should we be confident that other class members want you? You can't even identify the you know, the personal representative. You can't find the personal representative. You can't get that person to hire you. Isn't, you know, what makes us think you're going to be the right person to do this?
Well, Your Honor, we're not omniscient. We don't know the names and addresses of putative class members. We don't have that information. The employer has that information, but the named plaintiff and the class counsel don't have that information at the outset of litigation, and are not guaranteed to get that information prior to class certification. So the idea that whether or not putative class members ought to be—
Well, I mean, I take it you spoke to your client when you were hired. I take it you asked your client, who else works there? You know, are they interested in joining this suit? Don't we assume that level of interaction between you and at least your client?
Well, I guess you'd be suggesting that we would be engaged in potentially soliciting new clients through our present.
No, you're asking the court to basically solicit for you. That's the thing that really gives me tremendous pause. You're asking a court to send out a notice saying, you know, basically sue this, you know, defendant. That adds the court's imprimatur to your solicitation efforts in a significant way. And that's what the cases caution about this kind of notice about.
Well, Your Honor, Rule 23D specifically tells the trial court in order to ensure adequate representation, that one thing they can do is send out notice to class members and invite them to intervene. So this isn't some solicitation that I'm making up.
There's no class here.
Right. Well, Your Honor, Rule 23D applies pre-certification, and what I would point the court to its decision in Chambers versus RDI Logistics Incorporated.
That part I agree with, that Rule 23 is broad enough maybe to allow prior to the certification, but
well, Your Honor, then consistent with Rule 23D, which specifically says that the trial court can literally encourage people to intervene and bring claims.
No, it doesn't encourage intervention in bringing claims. That's not what the judiciary does. It protects the interests of, you know, people who've been reasonably identified as potentially prejudiced. It doesn't, we're not into what one of the courts described as barratry, you know, or helping you get clients. That's not what the court's supposed to do.
Well, Your Honor, I don't see this as an effort to try to get new clients. There's no other way to avoid prejudice when a case gets dismissed with respect to putative class members other than a new named plaintiff when there is no other class representative. That is the only way to guarantee that prejudice does not flow to putative class members. If there's another method, I'd love to hear it, but that is the sole method by which you can ensure that people maintain the same statute of limitations they otherwise have. So, Your Honor, I would like to sort of get back to the argument. First, just very briefly, as I'm now running out of time, is that, again, if we have a fiduciary duty to act in the best interest of putative class members, then the court ought to recognize at least some limited authority by which we can act pursuant to that fiduciary obligation. And at a minimum, Your Honor, ask that inform the trial court that the named plaintiff has passed and request that a notice be issued to the putative class. And what I would note is that a personal representative isn't a good solution to this. A personal representative does not, the named plaintiff in a class case has an obligation to do what's in the best interest of putative class members, but a personal representative doesn't. They don't have to participate in the case at all. They don't have to hire counsel. They don't have to do anything to assist putative class members in any way at all. Now, even if we don't have that authority, then the trial court certainly does and has wide discretion in order with respect to issuing notice. Rule 23D, this court is called the trial court the guardian of the absent party's interests. And Rule 23D gives the trial court tools to effect that duty. The court can at any stage of the action may require such security and impose such terms as shall fairly and adequately protect the interests of the class. And the rule explicitly gives the court the discretion to do that. And Your Honor, with respect to potential prejudice, again, if this case gets dismissed, the putative class no longer gets a favorable statute of limitations. They literally begin to lose wages as a result of dismissal of the case. And that is the kind of protection that it warrants at least the issuance of notice, so that consistent with due process, that we can protect the interests of putative class members. And again, I would point the court to the
I'm sorry, I'm gonna just stop you right there. Whenever somebody says again, that means we've got it. So thank you very much. And I'm gonna turn to Attorney Scott.
Thank you, Your Honor. Catherine Scott on behalf of Defendant Appellee Secure Home Health Care. This is not a class action case. Up until
it is a class action. I mean, it's a putative class action, and he is right that there's some flexibility on notice even prior to certification. I'm not saying there is any right here, but you do have to come to terms with the fact that you don't need a certified class to have some rights, right?
Well, I think that our initial argument would be, as you pointed out, that we do not think that Rule 23D applied in these circumstances. But I think, assuming for the purposes of argument that the rule could apply in some circumstances to operate to give the judge discretion to issue notice prior to class certification, it would not be in these circumstances, and it would be in circumstances as we have identified in our brief, extraordinary circumstances where there is some evidence of substantial harm to the putative class members should they not receive notice.
So, but how does go ahead, sorry.
What about the prejudice articulated by opposing counsel, which was, well, the only one that I understood was the tolling of the statute of limitations?
Right. My understanding of counsel's argument is actually even more narrow than that, which is that what isn't told is certain individuals' abilities to bring their own class actions should this one be dismissed under China Agritech. So what happens in the event that this action is dismissed is that their tolling resumes from the day that the complaint was filed. So they're in no worse position than they would be, for example, if class certification were denied. And there's no requirement that notice be sent out in that circumstance as well. The consideration would be whether there is some actual tangible prejudice to putative class members who have knowledge about the case and who were relying on it to protect their interests for some reason, not bringing their own claims. We don't have that here. We don't have any evidence of that. They are simply no different than any other plaintiff out there who has not brought their claim. So with respect to the individual statute of limitations, I don't believe that there would be any prejudice to an individual who is potentially a putative class member under this action. Their statute of limitations would begin running from the day that the complaint was filed. They don't lose anything. It's not as if they've lost the last 3 years. It just begins running from the date that the complaint was filed.
I'm confused how that would work in practically. So you're saying that if somebody else showed up right now and stepped in, they would have the same everything would be told because they would just step into the shoes of another, but no one's going to be notified. So I'm confused how this is going to work as a practical matter.
I guess I'm confused as to which part. If someone stepped into the class action or if someone brought another individual claim. If someone brought another,
he's saying, your opposing counsel is saying, look, court, send out notice because, to send out notice that this thing is going to disappear so that you can't basically free ride off of, me anymore because I've gone away. And he does have a point. You're not telling him who the other people are. Now, that doesn't mean he can't figure out. He shouldn't have been able to do that through his own client, but at least somewhat, at least to identify one or two other people. But I do see a practical problem, which is we don't know for sure whether people are relying on him to keep this going. And they're not being notified it's over. So isn't there a potential prejudice there?
Well, I don't know about potential prejudice, Your Honor. I think what the cases speak to is whether there's actual prejudice, whether there is actual evidence of putative class members having relied on this action to protect their interests. So for example, we were talking about the Culver case. I think if you look at the Culver case, not only does it have all the aspects that you yourself were pointing out, but it was also a class that had been certified that was going to be decertified. So there was some evidence that there were putative class members who knew about what was a class action and what was no longer going to be a class action. And if you compare those to the other cases that we've cited in our brief, such as Ballschmitter or Sapia, there is, in those cases, the notice was denied because there was no evidence that there was any prejudice to putative class members, the same as here. In the cases where notice was issued, there was, again, ample evidence that putative class members were relying on this action to protect their rights. There was publicity, both through the media and websites. There were affidavits. There were affidavits from counsel saying that they had had discussions with putative class members. There was an acknowledgement from defense counsel that putative class members knew. So I think the question you're asking is really whose burden is it at this stage of the action to show that putative class members would be prejudiced? And our argument is that it's the plaintiff's burden, which brings us back to the initial issue, which is there's no plaintiff. There's no one to argue against. There's no one to take discovery of. We're essentially arguing with the court at this point over whether notice is appropriate.
Right. How about the cases, although neither side brings them up, but the analogy where the defendants buy off the one plaintiff, right? The U.S. Supreme Court doesn't like that. I know this. No one bought this person off. He died. But is that different then? Where, again, why is that different?
I think the settlement cases are different. I think they're different both in sort of procedure of the case, and they're different under mass law versus federal law. So I think for mass law, when you're dealing with settlement, you have sort of, if you're settling the class, you have no opt-out. So that would make sense that notice would go out because whoever that class is bound to the settlement. I think where you have an individual plaintiff who's being bought off, I think whether or not notice would be appropriate in those cases would be on a case-by-case circumstance. Again, depending on how early it was in the action, whether putative class members had notice, whether they were relying on the named plaintiff to protect their rights. I think there could be circumstances where notice might be appropriate, but I don't think it's the same as where you have a plaintiff who dies before any discovery has taken place and before there's even any decision as to the merits of the scope of the class action.
So if this plaintiff dies, and say we agree with you and we decide no notice goes out, this plaintiff died, there's no personal representative, so this class action, someone else is not precluded from bringing a class action, right? Even though there's no opt-out here, if Mr. Moslinger finds somebody new tomorrow, he can bring a class action for that person, right? Is that right? Or not?
I believe he could, as long as the statute of limitations for that person had not passed. I think if the statute of limitations for that individual had passed, then they would not be able to be a representative of a class under China Agritech, but they would still have their individual claim so long as it was told based on this class action.
But okay, but again, remind me of how China, whatever it is, works in this context. So again, Mr. Moslinger's client dies. He doesn't want to just represent the next person. He wants to create a new class. Is he able to do that, or is the China case somehow get in the way of that?
I don't think he does, as long as he has a plaintiff who the statute of limitations on their claims have not run.
But he can bring that case as a
Without-
class. He can bring
Without
that.
the tolling, correct.
He can, right, he can bring a class action, but he has to start he doesn't have the benefit of your tolling from your earlier class action, or does he have the benefit of it?
For the purposes of the class action, he does not. That person has the benefit for their individual claims, but not for the class action. I also think that China Agritech.
Well, but again, so what is the status? If again, Mr. Mosinger finds a new client after we dismiss this, that class, he can bring a class action for that client as long as he can bring a class action. It's just the statute of limitations, is defined for that class over again, right?
Correct. And that person would maintain their individual claims if they wanted to bring an individual action and they were part of this class or they could argue they were a part of this class, this putative class dating back to 2016.
Now, from what I understand, there's other, does this record contain, there's some record evidence that there are other class actions here. They're not against your client though, is that right?
That's correct. There's at least one other that we're aware of that where Mr. Kingara was also the named representative.
Okay.
And the reason that's included in the record, Your Honor, is because it was part of the record in our case for the argument made to the Superior Court judge in support of issuing notice in this case. See, my time is running out, so I'll just sum up. So we would argue that what the Superior Court did in this matter is not only intrusive and disruptive to secure home health business operations, but is unprecedented under both state and federal law. Because there is no party on the plaintiff's side, the court is essentially acting as an advocate for alleged class members in a case that has no plaintiff, where there's been no discovery or other evidence on the merits or the proper scope of the class, no motion for class certification, and in fact, only the barest allegations that class certification would be appropriate in this matter. If you look at the complaint itself, which is at appendix 8 and 9, paragraphs.
So just to put a fine point on it, you're saying that the judge abused his or her discretion?
Well, I think it's a bit more complicated than that because we're answering the two certified questions.
Well, yeah, but you're
Yes.
arguing about prejudice to your client. That's not my standard of review. I'm trying to figure out what my standard is under Rule 23D.
Yes, I believe that 23D would be an abuse of discretion whether or not if the judge issued notice prior to class certification where there was no plaintiff, and we would argue that it was, especially where there's no evidence of prejudice, where there was no hearing, no findings, nothing except a filed complaint and an answer.
One thing that's a little tricky for us is we've got certified questions here, right? We have
Sure.
the certified questions. You could still win, but the certified questions sort of limit the discretion of judges a lot. If we adopted, for example, your view that you have to have a certified class in order to give notice, that's a big deal. And that seems inconsistent with the case law. Because in certain circumstances where we have identified potential plaintiffs, there is prejudice. So shouldn't we be answering the question that yes, in certain circumstances, you can give notice, but not here? That was the error. Is that, I mean, I know you want to sort of win big here, but winning big is not necessarily, that's requiring us to reverse some stuff out, some of our case law, isn't it?
I'm not sure that's true. I mean, as far as I'm concerned, the Massachusetts case law on 23D, most of that involved Chambers, for example, and the Superior Court cases that we cite. That involves the first sentence of 23D with respect to whether the court can issue a protective order for communications to putative counsel's communications to putative class members if it's abusive, if there's some harm, or if there's some misleading communications. It's quite different than what we have here. I do think that in these circumstances, it's pretty clear that Rule 23D would not apply, where you have a pre-certification putative class action with no plaintiff. And so I think these circumstances are quite different. I think for purposes of argument and looking at chambers, there might be some circumstances where it might be appropriate for a court to say, hey, there have been these misleading communications. We need to mitigate this. Something needs to be sent out to putative class members to do that. And again, the court would take a sort of heavy hand in managing the action, which is really the purpose of Rule 23D, to make sure that the putative class action is proceeding on a balanced ground. And I don't think that's what happened here, but for purposes of your argument, there might be some circumstances where communications notices to putative class members might be appropriate.